Um, so we are joined today by Jesse Hodern, who is the managing attorney for Prairie State Legal Services here in Rockford, Illinois. And Jesse's going to speak with us today about housing rights and how that can impact survivors of domestic violence. If you have questions throughout the presentation, feel free to unmute and ask them or throw them in the chat. Jesse's fine with taking them as we go. I do have a couple resources from Jesse to share, so I'll put those in the chat as the presentation is going on. And then as is customary, we also have an evaluation at the end that we ask you to fill out. So without further ado, I'll turn it over to Jesse. You can take it away.
All right. Well, thank you, Nikki, for coordinating this, and thanks everybody for attending. Like Nikki said, my name is Jesse Hodern. I'm the managing attorney for Prairie State Legal Services office here in Rockford, and I have been with Prairie State for 13 years now, believe it or not. But yeah, my presentation today is focused mostly on some housing rights for survivors of domestic violence. I do have a PowerPoint prepared, and so what I'd like to do is to go through using sort of a hypothetical that is based on a very realistic circumstance, a conglomerate of a lot of different cases and experiences that we've had in our office, and things that probably seem familiar to people who are advocating for domestic violence survivors as well. And then using that hypothetical sort of issue spotting and then trying to address what the legal protections are for somebody in those circumstances. So as Nikki said, feel free to ask questions, raise your hand, interrupt me at any point. I'm happy to try to address things. So as they come up, feel free to chime in. But I'll go ahead and I'll share my screen to start the PowerPoint. So everybody should be able to see that now. Just a general title screen here. Before I get started, I will just say for disclosures that anything I'm saying is just legal information and not intended to be used as legal advice. And everything that I say, nothing I say, I should say, should be construed as lobbying for legislative changes. What I'm providing here is just legal information about the current status of the law here in Illinois, and it's touching on some federal protections as well. So, getting started, my hypothetical here. We have somebody named Julie. She's been in an abusive relationship for several years and recently just left her boyfriend, Jordan. Jordan had been abusive and controlling for the better part of a decade and was violent anytime he didn't sort of get his way. But since leaving the relationship, Julie has been stuck in another sort of struggle, and that is, you'll see housing is one thing, and I've included a couple other bonus red flags for people to spot as well, but we'll focus on some of the housing struggles that she's facing. So Julie has a signed lease for an apartment. She's been there for about a year. It's a good location for her and her kids, close to school and close to work. Her boyfriend, Jordan, had moved in a couple months ago, and that's when things had gotten even worse. And now she's wanting to file an order of protection, but she's a little bit hesitant to do that because she's concerned that it may require her to find another place to live with her kids. She has asked the landlord to change her locks, and the landlord had done it for her in the past, but this time the landlord said, look, this isn't really my problem. You've just let him back in the past. You're just going to do that again. It's all too much drama. And now I have the city breathing down my neck because you have to call the police so often. So they're saying they're going to cite me as a nuisance property, and I'm going to start getting fined. So a week later, that landlord posted an eviction notice on her door, saying that she's being terminated from her lease for, quote unquote, disturbing the quiet enjoyment of her neighbors. Now, even though Julie doesn't have the money saved up to find another place to live, she doesn't want an eviction case filed against her, so she's put her things in storage and is basically couch surfing with her kids. She's applying for units that she really can barely afford on her own. She's had some promising leads, but between moving and going to court, she's missed a ton of work. Her boss is now even refusing to schedule her for shifts, and she needs the money to find another place to live. She's searching for more housing. She's applying for public benefits and for subsidized housing, but the process is confusing. The wait list is a year long, a lot of different hurdles. When she does fill out applications for housing, she sometimes has to disclose her current order of protection status. So in the hypothetical, we can assume that she's filed an order of protection. Some of the landlords stop responding once she discloses that, and others are just more blunt about it, that they're not really comfortable with that situation. So she's facing a lot of barriers, all stemming from the domestic violence. In addition, she got an email from the school that her kids attend saying that they recently realized that she had moved out of their school zone and will have to change schools. They can no longer attend that public school because they're outside of that zone. Just another bit of turmoil and change that she doesn't want to have to put her kids through. Like we see a lot with domestic violence relationships, this is a difficult thing to separate from an abuser, but these are a lot of different reasons why you might not expect that to be such a challenge. So that's the hypothetical. We can integrate that a little bit as we start to go through the statute. But first and foremost, one of the main issues that came up here was she was concerned about filing a petition for an order of protection because she wasn't sure if that would require her to leave her apartment. Under the Illinois Domestic Violence Act, you, as the petitioner, may be granted exclusive possession of your residence, both in the emergency order and a plenary order. The court looks at whether or not you have the right to occupancy. If both parties have the right to occupancy, then the court balances the hardships to the parties and to any of the children that they support. The hardships are presumed to favor the petitioner, and the respondent has to rebut that presumption by preponderance of the evidence that the hardship would clearly outweigh, the hardship to the respondent would clearly outweigh the hardship to the petitioner. So in the hypothetical, Julie really should have been granted exclusive possession of the apartment in an emergency order or at a plenary order stage. Jordan had just moved in, her boyfriend. He was not on the lease as I drafted the hypothetical. He moved in, but he was not on the lease. Changing locks. In our hypothetical, Julie had asked the landlord to change locks. Illinois has the Illinois Safe Homes Act, which does require a tenant or does require a landlord to change the locks. The tenant can request the locks to be changed if they reasonably believe that they or another household member are under a credible imminent threat of domestic violence. There's not really a definition of credible imminent threat or exactly what that entails, but under the circumstances, it seemed like the landlord was pretty aware of what was going on because maybe the locks have been changed in the past, but there's not really a set number of times under the statute that a landlord may be asked or required to change the locks. So the whole response in the hypothetical that, well, you're just going to let this person back in, or I did it once and that's enough, not really what the statute says. It could be complicated if the threat of domestic violence is from somebody on the lease versus off the lease. If the domestic violence is from somebody who's not on the lease, then in our hypothetical, like Julie, she would have to provide some type of evidence to the landlord to support the claim of domestic violence. That could be just a petition for an order of protection. It could be a police report. There's not any, particular requirement that she has an actual plenary order of protection, as long as the domestic violence is being perpetrated by somebody who's not on the lease. So the request wouldn't need to be supported by, in that situation, a plenary order of protection, for example. It gets more complicated if the person perpetrating domestic violence is on the written lease, because in that circumstance, the statute requires that the request to change locks actually has to be accompanied by a plenary order of protection. Same is true if it's just a verbal lease. It doesn't prevent the landlord necessarily from doing it. In other words, the landlord could honor the request even if a plenary order of protection has not been entered. But under the statute, in our hypothetical, unless Julie, if let's say Jordan was on the lease, and Julie made the request for the landlord to change the locks, the landlord could refuse unless Julie provided a copy of a plenary order of protection granting her exclusive possession. So it is more complicated if the respondent is on the written lease to get the locks changed. And there are time frames involved, pretty quick turnarounds, 48 hours after the request and all accompanying necessary documents. The landlord has 48 hours to change the locks, or can give the tenant permission to do that. The tenant, under some circumstances, can do it if they don't have a response from the landlord within 48 hours as well. But oftentimes what I hear as pushback from landlords is that, they don't want to have to sort of eat the cost of changing the locks 100 times. The statute actually does allow the landlord to charge a customary price for changing locks. So, I don't think it can be exorbitant, but whatever a customary price for changing a lock might be. Some landlords have keypads. Some landlords have locks that can be rekeyed without having to change the entire door lock and lock deadbolt. But anyway, I think as long as they are changing it so that the access is restricted, I think that's fine. If the landlord fails to change the locks within 48 hours, the tenant can change the locks even without the landlord's permission, but must do so in a workmanlike manner, whatever exactly that means as well, and basically provide the landlord with access or with keys within 48 hours of changing the locks themselves. So if the tenant doesn't hear back from the landlord within 48 hours, or the landlord doesn't do it within 48 hours, technically, tenant can do the work themselves and have the locks changed as long as they do it in a workmanlike manner. There are some protections in the statute for landlords not being liable to damages to the property if somebody is unable to access their property. So that was another issue that landlords have brought up, where they don't like to lock people out in those circumstances because they're afraid that person will have a claim against them for being locked out. But there is some insulation in the statute for landlords who are complying with these requests. Another important protection under the Safe Homes Act, other than changing locks, is to just end the lease and to move early. The landlord has, the tenant can provide the landlord written notice that they are under a credible imminent threat of domestic violence and that they have left the premises. A lot of times this is confused, where people believe that once you give notice that you have 3 days to leave. And that's not really what the timeline is. You just have to give written notice before you leave or within 3 days of leaving. So you could give notice and leave a week later as long as you gave notice before, or you could leave first and make sure that you give the notice within 3 days of leaving in order to, trigger the protections of the Safe Homes Act. So it's a bit of a confusion that people misunderstand, that once I give notice, I have to be out in 3 days. Not really what the statute says. You can give notice before leaving, or if you leave first, give notice within 3 days of leaving. And even beyond that, I'd say giving notice as quickly as possible, even if it's beyond the 3 days, would probably be a good idea. The Safe Homes Act provides confidentiality protections for people who enforce the statute or you take advantage of the protections in the statute. So if under the circumstances the tenant has to move and relocate and ends the lease early, or does ask for the locks to be changed, the landlord cannot reveal that to future landlords, and also cannot share any of the details of the tenant in exercising those rights. So it provides some confidentiality in terms of landlord references and whether or not the landlord is allowed to disclose those things to future landlords. So some, again, important protections for people trying to find new housing. This statute also cannot be waived or modified in any lease or separate agreement. So if you see a lease that says that the Safe Homes Act is waived and the protections under there are modified in any way, that provision of the lease would not be enforceable. The statute always governs over the contract. So, all right. Moving on to another statute. The Illinois Human Rights Act prohibits discrimination in real estate transactions, which includes rental and leasing of real property. In the hypothetical, we were talking about Julie, and she was being evicted or terminated or threatened with eviction by her landlord. Basically, the landlord said all this drama, really referencing the domestic violence that she was experiencing. So that's one aspect of possible discrimination, where she's being terminated because of domestic violence. But also in her applications and seeking out additional housing, being told that she needs to disclose her order of protection status on an application, or denied for housing because the landlords that she's applying with are concerned about that kind of drama in their properties in the future. So discrimination in the Illinois Human Rights Act, there are several different protected categories. And in Illinois, under the Illinois Human Rights Act, one of the protected categories is order of protection status. And so you cannot be discriminated against based on your order of protection status in a real estate transaction. So in a rental transaction, a landlord, a property management company, they cannot discriminate against you just because you have an order of protection. What does order of protection status mean? It really just means the status is being a protected party or protected person under an order of protection. It doesn't mean that you are even the petitioner. You could be just named as an additional protected party. So a little bit of a nuance there. Most of the time we're working with the petitioners who are facing the discrimination based on them being a protected party in their petition. So it is a civil rights violation to refuse to engage in real estate transactions or deny real property, or to discriminate in making available a transaction, or to alter the terms, conditions, or privileges of a real estate transaction. So to give some examples of what this might look like, I've seen landlords say, well, all right, I want to give you a chance. I understand that, you've been a victim of domestic violence, and I want to help you out because, I have a big heart, and I'll just charge you a double security deposit in case your ex-boyfriend comes to the property and tries to kick the door down. That way I feel covered. Well, you can't alter the terms, conditions, or privileges of a real estate transaction based on order of protection status. So charging a higher security deposit because they assume or perceive that this tenant would be more of some sort of a risk to their property could be considered a discrimination, a violation of the Illinois Human Rights Act. Additionally, failing to make available or to make any statement or to use an application form that inquires about protected statuses. So in the hypothetical, and I've seen in real cases, an application for a rental property asking whether or not you have any pending court cases, or then making statements overtly that, well, I see that you have some orders of protection filed in the last couple of years, and one currently pending, and I don't really want that kind of stuff going on in my property. So those kinds of statements or application forms inquiring into these things could also be civil rights violations of the Illinois Human Rights Act. So again, just using different criteria or methods that have effect of subjecting individuals to unlawful discrimination. There's some exceptions for whether they achieve a substantial, legitimate, non-discriminatory interest. But that's sort of a burden shifting issue that comes up maybe during litigation. So the landlord would have potentially a defense if they could prove that it was for some sort of other necessary, achievable, legitimate interest that could not be accomplished in a less discriminatory way. All right, we're going to move on. We're going to keep flying through several different protections here. So next is nuisance property. In the hypothetical, Julie's landlord was complaining because the city was breathing down his neck because Julie has called the police out to the property so many times. Well, she's calling the police or emergency assistance because of domestic violence. In many areas, in many municipalities, they have adopted nuisance ordinances. And Rockford, for example, has a nuisance ordinance. And this is the definition. Basically requiring 3 or more instances of the same property during a 120-day period, and law enforcement or code enforcement personnel coming out to the property. Could be flagged as a nuisance property, and there could be fines or penalties assessed through an administrative process that the landlord could be on the hook for, the property owner, if the city has dubbed the property as a nuisance. Well, thankfully, in the Rockford city ordinances, we also have exceptions for domestic violence. Any calls that come to the property or come from the property for emergency assistance or for law enforcement related to domestic violence are not counted. So there are exceptions for people with disabilities or for domestic violence calls to the property, that they are not considered nuisance properties for having to make those kinds of bona fide emergency calls out to the property. So if the landlord is being pressured by the city because the property is being flagged as a nuisance due to domestic violence, there should be protections for, of course, the tenant, the victim of domestic violence, but the landlord also should be aware that the city shouldn't be flagging these if these are bona fide calls for domestic violence or disability-related emergency calls as well. On the slide here, I've noted that there was pending a Senate bill in the General Assembly in Illinois called the Community Safe Through Stable Homes Act that would modify the municipal code to require, as an exception to nuisance ordinances across the state, that these exceptions are applied. So I'm not sure what the most recent update on that pending legislation was, but that I believe is on the horizon, just as a little bit of a heads up there. Finally, effective January 1st, the Illinois Department of Human Rights has been tapped into by the General Assembly to create a summary of key rights and remedies that tenants are protected with if they are survivors of domestic violence. And it will be required effective January 1st that landlords actually attach that summary to any residential lease that they enter. So we'll see if the Department of Human Rights creates that handout effective January 1st. Landlords should be attaching it to any residential leases. So at least on the front end, tenants in a residential lease will have a handout summary of their rights if they are experiencing domestic violence in relation to their rental property. So I think that's it for my slide and my hypothetical. Went through all that pretty quickly, so I would be happy to talk about any of the aspects of that, or maybe there are some additional things people have questions about, not tackled or addressed directly, but I'd be happy to open it up if people want to have more of a discussion.
Thanks, Jesse. I did also put those handouts in the chat while you were talking regarding exclusive possession and the housing rights as well.
Thank you.
Yeah. Anybody? Oh, sorry, go ahead.
Well, I guess I'll just I'll maybe address a couple of the, I don't know what to call them, the Easter egg additional issues that I put in there about in the hypothetical, the Julie was not being scheduled for her shifts now because she's missed a lot of work. She's had to take off work to maybe find housing, to attend court dates, to meet with advocates, to do safety planning, to go to counseling, to go to the hospital, all related to domestic violence. And now she basically has been fired or not scheduled for shifts, and her, boss is giving her a hard time. Well, depending on the size of the employer, she very likely has protections under VESA, the Victims Economic Security and Safety Act in Illinois. In Illinois, there are several weeks of protected leave that survivors of domestic violence can take. It is unpaid leave, potentially, but it is protected leave. So she should not face retaliation or termination for having to take protected, even if it's unpaid leave, to pursue these things as they relate to domestic violence. So that was one of the little additional plugs I put in for the hypothetical. And then at the end, second one was, she got a letter from the school or an email from the school saying that, well, we found out that your kids are no longer living in this school zone. And so, you're either going to have to start paying tuition to go to this public school, or you're going to have to re-enroll them in their different zone where they're currently living. In the hypothetical, she was couch surfing because she moved out to avoid eviction. So she would fall under the definition of homeless in the federal McKinney-Vento statute, and the school should allow the children to finish their academic year wherever they're falling. If it was currently right now in October, the students, her children, would have the right under that federal statute to finish whatever their current academic school year is through the second semester. So just an additional protection outside of the housing kind of context, but this is a very common fact pattern that we see at Prairie State, where somebody is coming in with domestic violence issue and primarily want advice or services related to seeking an order of protection. But as you can see, there are just a number of, I wouldn't even call them ancillary issues, but they are additional issues, important issues related to housing, school, and economic support, jobs. So a lot of different protections and a lot of different issues that come in with these types of cases. So anybody have any comments, questions, or anything even outside of the immediate issues that I covered?
I do have a question, of course. With exclusive possession, say the petitioner of the order of protection, they don't necessarily need to be the owner or leaser, but if they have children in common or the children live there, then that would give them right to ask for that. Is that right?
Yeah.
Even if they're not married?
Yeah.
Okay.
Yep. If you have the right to occupy, which is more broad than being even a tenant or an owner, it basically means that whoever really is the owner or somebody who leases the property has given you permission to be there. Or somebody who's the owner or the leaseholder, that you live there with their children in common. So in the hypothetical, if maybe Jordan, the boyfriend, was the leaseholder, but the children that they have in common live there with the petitioner, Julie, she would have the right to occupancy, even if she's not on the lease. She would, so.
What if they weren't his kids? That changes it.
Well, even still, if she had been invited in and, allowed to move in with Jordan, she could argue a right to occupancy. So.
Okay, thanks.
Yeah, it's pretty broad in the statute. I think it's intended to be broad on who has the right to occupy, and I think that the intention or the decision to use the word occupy versus own or tenancy or lease was probably an intentional decision from the legislature, because the word occupy is even a lower sort of property interest or property right than a tenancy would be, for example. So.
All right. I also don't think I ever realized with the lock change, I knew that was allowed, but I didn't know that the victim or petitioner could be responsible for the costs. So that was good information to hear.
Yeah, and I think I don't necessarily love to publicize that all the time, to pass that along, but it is in the statute, and when we receive pushback, oftentimes the landlords are concerned about cost, and oftentimes my client, the tenant, would say, like, I'll pay for it. I'll give them the $50 for a new lock or whatever it is even. But like I mentioned, some landlords do have just the locks and the knobs that you can rekey very easily, or have codes that could be changed instead of having to replace all the mechanisms. So that could be really pretty easy and cost effective if they have those types of locks installed already. But yeah.
Sure. Okay. Are there questions from others